It has been another full day of law enforcement witnesses laying out the police department's policies on crisis intervention and use of force, which is a huge deal in this trial. But before that happened, before day 7 began, it started with a hearing outside the presence of the jury concerning Morries Hall. Hall is the individual that was sitting in the passenger seat in the Mercedes SUV with George Floyd on May 25th last year. Hall, who's currently in jail, was supposed to be a witness for the defense in the Chauvin trial, but he informed the court that he plans to take the Fifth Amendment and asked that a subpoena issued by the defense for his testimony be quashed.
I wanted to outline those areas that I believe Mr. Hall may face questioning. The first area where he would be invoking his privilege against self-incrimination is any activities that took place on May 25th, 2020, both before and after police arrived. Okay. Mr. Hall's testimony in these matters would specifically put him in the position of being in very close proximity to Mr. Floyd. There's an allegation here that Mr. Floyd ingested a controlled substance as police were removing him from the car. A car, by the way, that has been searched twice, and to my understanding, drugs have been found in that car twice. This leaves Mr. Hall potentially incriminating himself into a future prosecution for third-degree murder.
All right, let's bring in my colleagues, Janley Painter, who's in Minneapolis, Julie Grant, and Michael Ayala. Janley, this argument from Morries Hall's attorney basically is, hey, he could be putting himself in a position, if he is not granted immunity, for further prosecution.
Exactly. So basically she's saying that any sort of testimony about what happened Memorial Day 2020 would or could expose Morries Hall to a potential third-degree murder charge, in that the testimony so far in this case has provided that he was a passenger, he was there when George Floyd was arrested, and through George Floyd's girlfriend, Courtney Ross, that Morries Hall was the one that supplied controlled substances to George Floyd and herself. Well, as the lawyer said, drugs were found in the vehicle that Morries Hall is on video inside. So let's look at specifically what she's meaning when she says exposed to the third-degree murder charge here in the state of Minnesota. It's Section B of the statute. And remember, Derek Chauvin is charged with Section A, third-degree murder. So this is a different part of the statute, which is she's referring to. And it says whoever without intent to cause the death proximately causes the death of a human being by directly or indirectly unlawfully selling, giving away, bartering, delivering, exchanging, distributing, or administering a controlled substance. So basically the theory here is that the public defender is saying, Your Honor, because the contention is that George Floyd may have overdosed from the controlled substances allegedly provided by Morries Hall, he could be open to this liability. So the judge, after hearing arguments from Adrian Cousins as well as the prosecution, has set up sort of a timeline of what is to happen next for Morries Hall, who is currently in custody, by the way, on a completely different matter being held. He appeared via Zoom, but here's what's next. He's going to ask Eric Nelson to specifically outline a limited scope or a narrow topic of questioning that may be permissible under the law, which is basically his observations of what George Floyd was doing in the car, which the defense wants him to say that George Floyd suddenly fell asleep in the car before police arrived. So then that question and answer would go to the Morries Hall's attorney. They'll review it. They'll say, Judge, we don't want to say this, or we will say this, but ultimately the decision will be from Judge Cahill in the coming days as to whether or not the invocation of the Fifth Amendment would be proper given this narrow topic of questioning he seemed inclined to allow earlier this morning.
Okay, two things to talk about. First one, the state of Minnesota, Michael, is possibly going to charge him with third-degree murder when the state of Minnesota thinks that George Floyd died of the neck restraint, not of the drug overdose.
Yeah, I mean, I was surprised he hadn't been charged to this point, and that's exactly the reason why he hasn't been charged. And, the problem for the state here is that if he comes in and he invokes the Fifth Amendment, as much as we want to say everyone has that right, there is sort of this negative implication with it. And then by association, George Floyd might have some of that negativity rub off on him. So they were very, very clear that that's something they didn't want to happen in court, and I think rightfully so.
Julie Grant, the openings with Eric Nelson, he said to this jury that Morries Hall was going to come in and say that George Floyd conked out, was asleep in the SUV right before the police showed up and they couldn't wake him up. Now what? And what would you do if you're Judge Cahill? How is he handling this?
That's such a tough question, Ted. So a couple things to consider. So what we're talking about here essentially, and this has been a big trend the last several years with drug deliveries and when overdose deaths result. Many states have started prosecuting these cases as drug deliveries resulting in death. So this is the potential criminal liability that Morries Hall is worried about being exposed to. So he's got his Fifth Amendment right, which is a consideration for Judge Cahill. The other enormous consideration for Judge Cahill is Derek Chauvin's Sixth Amendment right to what's called compulsory process. As a defendant, when you are accused and you are cloaked in the presumption of innocence, you have the right to attain witnesses to testify in your case, in your favor. Someone can come in and testify, and you can compel that process to happen by way of court subpoena. So it is the compulsory process clause in the Sixth Amendment that Judge Cahill really has to consider here, because at the end of the day, it is Derek Chauvin who is criminally charged. And the state's legal theory is that Derek Chauvin murdered George Floyd by pressing his knee on his neck, causing positional asphyxiation due to that compression. So a couple other things to think about, too. If the state was okay with this coming in, why not just say, you know what? That's not our legal theory. We don't believe that George Floyd died because of a drug delivery that resulted in death. So we're fine with this. We'll give him immunity. And that's a conversation that perhaps the court might even have with the state, because this is such a tough balancing act to get through, Ted, because you've got the Sixth Amendment right that protects Derek Chauvin as the accused, and then also Morries Hall wants to invoke his Fifth Amendment privilege to say, I'm not going to go give this testimony. So I think when you really sift through it all, you can see where, look, he could be, as I believe it was Matthew Frank, the prosecutor, who called it an alternative perpetrator. Is what the defense theory may be, that, look, this was an overdose death and Morries Hall very well was the provider, so let's bring him in and show the jury. I think at the end of the day, this testimony is going to come in.
Well, it seemed like at least limited, a limited version,
right.
That's where Judge Cahill is going. All right, let's talk about Johnny Mercil. He is on the stand, and he's the guy. He's in charge of training and specifically use of force. Chanley, he's the latest in a long string of this. The jury has really gotten an education on what it takes to be a police officer and the different types of training they've been exposed to, but also the defense used Mercil to their advantage a bit on cross.
Yeah, this was a huge witness, especially for the defense so far. Now, this is arguably one of the first use of force experts this jury has heard from. He specifically trains and teaches in the Minneapolis Police Department on use of force, specifically drilling down on a lot of the definitions, a lot of the manual before the jury, with a note of what is proper, what is authorized, and what is unauthorized. And some things I picked up and noticed is that his testimony runs counter to some of the other high-ranking Minneapolis police officers this jury has heard from. He's basically said that the knee on a prone position suspect handcuffed could be authorized under certain circumstances when a suspect actively resisting. And of course, defense taking full advantage of some of those blurred lines, if you will, on what is proper, what isn't proper, and what was trained. Whereas former officers have clearly said that Exhibit 17, the photo of Chauvin's knee on George Floyd's neck, was not authorized or proper under any Minneapolis police training. So again, I think we've seen that the defense will use a lot of these answers on cross in their closing arguments when they go and argue their case before the jury at the end of this.
Yeah, Michael, this one is, kind of raise your eyebrow a little bit. When Eric Nelson was questioning him, he was agreeing on a lot of it and really pushing, and he kept agreeing with these hypotheticals.
Yeah, he did. I was surprised by that. But again, he's answering truthfully. We have to assume he was. He's under oath. And in fact, the issue, again, might be with the actual training that's going on. But if you remember, Eric Nelson, when he was doing his voir dire, was consistently asking folks, would you be willing to, set aside the fact that you don't agree with something or certain training if that, in fact, it was the case? And he would get them to promise to agree. He's going to remind them of that when he's doing his closing. So even if you don't agree with the training, he's going to still expect them to understand this is how they were trained. But what's interesting, about Mersel's testimony, I thought was that, again, the most important part of this case for the defense in terms of this aspect of their defense is that 4 minutes, explaining that 4 minutes and 40 seconds that Floyd is completely unresponsive. Why the neck? Why he continued on the neck? And this is the second time he's gotten someone to say that they have seen someone awake from being out and come up and be violent. And again, that's helping them explain why that it was still this sense that even though he wasn't responding, that he needed to be held down.
Julie, quickly run out of time. Was Mersel helpful for the state or the defense? Who kind of took advantage more?
Oh, I think the defense, Ted. I think at the end of the day, he came away being more helpful to the defense. And this is a risk that the state runs when you overtry a case. They already had great testimony from Sergeant Ploger, from Lieutenant Zimmerman, talking about how Zimmerman's words, totally unnecessary. Ploger saying that when the resistance stops, the force should stop. If you keep overtrying it, you keep putting more people up there and you're not sure what they're going to say, you get what you got here, where he agreed largely with the cross-examination questions. And so I think it's a lesson to be learned. Once you get the facts out that are favorable to you, stop and only elicit what else you need to prove your case.
Yeah, great point. All right. Thank you all. We're going to step aside, take a break. We'll come back more of the Floyd family press conference outside the courthouse when we return.